Sarah Boone was in court. I'm pretty sure there's going to be something she's not happy about. Let's check this out. Oh, by the way, I interrupt a lot. So if you want just what happened without any interruptions or commentary, this is not the channel for you. Let's go.
Case number 23, Sarah Boone, State.
Mr. Cacciatore?
Dave Cacciatore on behalf of the state.
Ms. Boone, good morning. Could you please raise your right hand so Madam Clerk can swear you in?
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ma'am, good morning. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-77.
We also have a representative from Prison Break Investigation. Sir, if you could come forward, please. If you could, sir, raise your right hand. Madam Clerk's going to go ahead and swear you in.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, sir, good morning. Could you state your name for the record?
Billy Lane.
And Mr. Lane, what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator for Prison Break.
Okay, very good. The reason the court had this hearing this morning is the court has found that Ms. Boone has forfeited her right to counsel and waived her right to counsel alternatively by virtue of her conduct in this case. As such, Ms. Boone is currently representing herself. The court has been working diligently to provide you the discovery. I received your letter, ma'am, and I have reviewed it. We have not forgotten about you. It's just taken some time in order to coordinate the appropriate processes with the jail. In conversations with the jail, a laptop has been secured and will be issued to you after USB drives are provided with all the discovery. Upon the jail's receipt of those items, the following provisions will be adhered to. The laptop, charging cable, and USB devices will be kept in the FDC main control room when not in use. At no time will the charging cord be placed in the housing unit. Upon the return of the laptop to the FDC main control, the laptop will be placed on the charging cable to ensure it is available for the next day's usage. The laptop and USB device is to be accounted for with the control room inventory. The control room DST or CO will make logbook entries for the issuing and returning the USB device and laptop. The dorm officer will make logbook entries for the receiving and returning of these items to the applicable movement officer. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to inmate Boone. The laptop and USB device will be available daily to you, Ms. Boone, between 0800 and 1600 hours. A notebook entry will be completed in IMS for every issuance of the laptop and USB device to yourself, Ms. Boone.
Did you notice the annoyed sigh at the very beginning from Boone? I like how the judge set out how he's not forgetting about her. He's letting her know. He's giving her the care that she has complained that she hasn't received. So he's letting her know she's important. And this is all on the record. You may recall that Billy Lane was her investigator before. So he's been there sort of all along. And this is paid for by the state, by the taxpayers. So she hasn't lost everything. And he said she'd forfeited her right to counsel, and I wish he'd said forfeited her right to court-appointed counsel, because that is actually what's happened. She can still go and hire counsel if she wants. That has not been disallowed. It's unlikely. She's just not able to have counsel paid for by the state. And it sounds like they had to come up with a whole new procedure, a whole new way of operating in order to accommodate her. So if she complains, when she complains, because I'm sure she will, that it's not good enough, everybody has to keep in mind that they've come up with a whole new thing just for her. So they're giving her a laptop, they're giving her all of her disclosure, which she has been asking for all along, and fair enough, she has a right to all her discovery. There have to be procedures, and it sounds like the judge has taken into account things she's complained about, such as this place where she's being held is not private. She's bunked in with a whole bunch of other people, so you can't have discovery laying around, and you can't have boxes of papers everywhere, because you can imagine she would be complaining that people could look at it. She would have nowhere to keep it while she sleeps. So this makes a lot of sense. And if it's all on an electronic device, it's not so easy to lose. I also think it's great, and Sarah may or may not understand the significance of this, that there has to be a notebook entry for each time that Sarah accesses the laptop and her information. Because if later she complains that she didn't have enough time, the court can then look back and see whether or not she did, in fact, access the information frequently or not. They can see whether she worked on it or not. And a lawyer has to docket their time. She's her own lawyer now. So if a lawyer writes a letter or works on anything on a file, makes a phone call, whatever they're doing, they're docketing how much time that takes so that they can show the client, or if they're being paid by the state, they can show how much time was spent on various tasks. So they can prove that they've been working on the case and they just aren't just billing for having a cup of coffee. So Sarah's going to have to, in a way, be subject to the same sort of thing. So if she comes back later and says, I didn't have enough time to prepare, and they look back and see that she didn't access that information, that laptop, as often as she could have, then there will be an issue. Her argument will have less weight, and the laptop and the information will be available to her from 8 to 4 every day. Isn't that something? Like a normal job. So she can get up, she can go and work on that from 8 to 4 every single day. So all the complaining that she has done about lawyers not spending enough time on her case, well, she's her own lawyer now. She can spend all day, every day. She has a lawyer now dedicated full time to only one case, and that's hers. She happens to be the lawyer, sort of, but she can work on it all day. This is what she wanted. She wanted access to her discovery. She wanted this access in such a manner as to protect her privacy. And she wanted more time dedicated to her case. And here it is. He's laid it out. This is great. So we'll wait and see what Billy Lane has to do with all this. He may be the person who, is contact with the outside. She can utilize him to track people down, witnesses and such. So there are lots of ways that she can use him. And the court has called him in and he has to appear, and the state is paying for him. So it sounds like she's set up to the extent that you can be set up if you're trying to represent yourself. So let's see what role Billy Lane is going to play here.
The discovery was provided at the court previously and is in the two bankers' boxes that are in front of the court to your left, Mr. Lane. I'm going to order you, sir, to take possession and custody of that discovery that was provided to the court previously on June 28, 2024. You, through Prison Break Investigations, shall copy all of the discovery onto as many USB jump drives as necessary. The Judicial Administration Commission for the state of Florida shall be responsible for the fees and costs due to Prison Break Investigations for copying all of the discovery onto as many USB jump drives as
I understand now. The people at court, so a judicial assistant, a clerk, nobody can copy all of this information onto an electronic device because it's confidential information. So because Billy Lane was working for Sarah Boone under a defense lawyer, he's covered by privilege. So there's that lawyer-client confidentiality, even though he's not a lawyer. So if I went and worked under a lawyer and had to speak to the lawyer's client, I'm covered by that lawyer's privilege. Whereas somebody else copying all that information is not subject to those rules of confidentiality. The judge has set this up in a way so that Sarah is protected. So her rights and her confidentiality is protected here. It sounds like they've thought of everything.
is necessary. You will appear for a hearing with the court on August 1st, 2024 at 8:45 in courtroom 12A of the Orange County Courthouse, with the discovery and all USB jump drives containing the discovery. A representative from the Orange County Jail shall also appear for that hearing as well. At that point in time, Prison Break Investigation shall hand deliver all USB jump drives containing the discovery to the representative from the Orange County Jail in order to be placed onto the laptop that is currently secured and to be issued to the defendant for all trial and court preparation.
Oh, very good. So instead of having Billy Lane take the information or take the material to the jail, this judge is not going to allow there to be any holes or gaps if he can help it. He's having somebody from the jail show up in court. This is unusual, so that this information can be handed over, so that is on the record too. Everybody is sort of on notice that we're not messing around here. Every one of you is going to do your job. And Sarah can't claim, oh, I didn't get it, because everybody's going to see it. It's going to be on record. Lane is going to show up. They're going to do the handover. Somebody from the jail has to be there. So it will be on record that the jail has the information. So it sounds like somebody went to quite a lot of trouble to make these arrangements with the jail. This judge is cutting off arguments that Sarah would make before it can happen. She's not going to be happy with that, but the reason she's not going to be happy with that is not because it's against her rights. It's because it takes away all the possible arguments and complaints she has in advance. And really, the judge is protecting her here.
Do you have any questions for me, sir?
I have a conflict for August 1st, Your Honor. I'm
Okay.
supposed to be out of state from Tuesday until Friday of next week, which I believe would encompass August 1st for my son's wedding.
Okay, well, congratulations. When do you return from your son's wedding, sir?
I will be back late Friday evening, so I'll be available the following week.
Okay, will you be able to complete that task by that time?
Yes, sir, I'll do my best.
Okay, sir, we will see you on give me a second, I want to make sure I get the date right. Monday, August 5 at 8:45.
Yes, sir.
Okay, you'll be given a copy of the order that I just read from. Ms. Boone, you'll also be given a copy of the order. Do you have any questions for me?
I am thoroughly confused. Was the notice ever put online for this or mailed to anyone? I don't even know why Mr. Lane is here. I don't know why I'm here.
Well, ma'am, you are now representing yourself, and previously you had requested to appear at every hearing that was held. As you are now representing yourself, the court cannot have any hearings regarding your case without you being here. I put on the record and explained to you the process that the court has had with communications with the jail. I'm not allowed to look at any of that. I'm not allowed to copy any of that. So in speaking with the jail and understanding that you still have a private investigator that was provided to you through the state that's being compensated by the state, you're still allowed to utilize his services. The protections of the attorney-client privilege are still applicable to him, so he's able to review any of these documents, ensure that they are safely copied without violating any terms of the privileges. Those will
Sorry, I just cut him off. How pedantic is she? Her concern is that she wasn't given notice? Am I understanding that right? He just handed her everything she wanted, taking into consideration everything she'd said. And it's like, did she not hear that? And she's saying, why am I here? He just told her.
will then be placed on multiple USB drives and provided to you. Those USB drives will then be uploaded to a computer that has been secured for you at the jail for you to access all of that information.
Okay. My question is, was a notice of hearing posted or mailed to anyone to where apparently the news crews obviously got it? How is it that I do not know anything about this other than my bunk being kicked at 3 o'clock in the morning telling me I have court?
Ma'am, I have no other way to get in touch with you other than setting the hearing, which was set yesterday once I received confirmation from the jail as to the processes for how this would work.
I think there are two things here I want to comment on. One is, if the jail was notified the day before, the night before, they could have told her. The jail could have told her that, hey, tomorrow you're going to court, instead of just waking her up and saying you're going. They could have done better on that. But if she wants more notice, then she has to think about what she's asking for here. They set the hearing the day before, so they have to let her know somehow. So they let the jail know. And the jail needs to know because they have to transport her over, right? Well, if she wants something in writing, that's going to take time. And she's been complaining. She wants this to get going, get the show on the road. So if she's going to demand notice, she has to understand what the consequences are of that. Because if now somebody has to write up paper and then get it delivered and go through a different process instead of just getting her into court, well, the days tick by. That clock ticks away. And she won't be happy with that.
And I understand that your case is important, and I want to move it as efficiently, as diligently as possible. I know that you've been waiting for this information, and it took some time to confirm the process with the jail. You've advised me that you have very limited space, you have almost no privacy, you have a small drawer where you can keep some personal effects. We could not send all of those boxes with you to the jail, and the jail advised me that they cannot take all those boxes. A process had to be created to make sure, and this is the process.
The process that I was explained after speaking to a couple of sergeants, and I've been waiting for that, and I would much rather prefer a hard copy of these to where I can write on them as opposed to anything that's on a laptop.
I am unable to provide.
Oh boy. First of all, he told her on the record, your case is important. So when she goes on and on, nobody cares, everybody's forgetting about me, I'm not important. Well, you're so important, Sarah, that they made a whole new procedure just for you. And he's also validating. So there's some psychology happening here, and you can see it doesn't work. It's not working because she is invested in complaining. She is invested in being the victim. She is invested in being able to say it's not fair. So if you cover off all your bases in one area, well, she'll find something else. So he's validating her. You're important. We're doing this for you. We want to do this fast. And he tells her this is the process. And she starts to argue, but she doesn't actually have an argument, so she goes off on something else. The argument she started after he said the process is this, and she said, well, I was told the process was, and she didn't actually finish. Whatever it was that she heard or thought she was told is going to be right in her mind because she has to argue back against the judge. You know, the judge doesn't know anything, right? Well, she couldn't even finish her sentence. There is no process that she was told about that is somehow different. She didn't even make the argument. She just switched off to, well, I would rather have the boxes. Well, wait a minute. She has complained and in writing that there is no privacy there. And how is she supposed to look at her disclosure with 65 other people there? How is she supposed to do that? She complained about this very thing. She didn't want the boxes. You know what she wants? She wants to be out. She wants to be out and looking at all these boxes out somewhere else. They're giving her exactly what she wants, and now she wants something else. It's called moving the goalposts. It's never going to be good enough. Doesn't matter what they do. The judge could come down off the bench and kiss her butt, and it would not be good enough.
Provide that for you. I have been provided the process has been provided to me by the Orange County.
Do you see her rolling her eyes? They're handing her on a platter everything, and she is just so annoyed.
I understand that's your preference, but I can't do anything more than what I've done right now.
I understand. And I have had other information given to me, which is why I've been waiting for the boxes for them. So I don't know, is this something that I need to...
She's had other information given to her, and that's why she's waiting for the boxes? Wonder what that's about.
pursue continuously still for me to be able to receive my hard copies? Because no one tells me anything.
I cannot answer that question because that may call for me providing you legal advice, which I am prohibited from doing.
Okay. Well, because I have no other way of contacting you other than in a letter, and it's AKA worldwide. So am I supposed to go back and speak to the captain and whoever else it is that I might need to speak to in order to receive these?
Again, I cannot answer that question. All I can tell you is that we will have a hearing on August 5, whereby which Prison Break Investigations will provide all of the information on USB drives. Those will be provided to a representative from the Orange County Jail, who will place all that information on a laptop for you to use, and that's accessible for your use from 0800 to 1600 every day.
She's not listening to him. He gave her an answer. She didn't like the answer, so she just asked the question again, which is, I want the hard copy. Before it was, well, you can't send me these boxes of things because there's all these people, but now I want the hard copies and I have to continuously pursue. You see, she's already setting up how she is going to be victimized by the court. She's already got it figured out. Continuously pursue. She is this fighter who is just, this endless battle. If they really give her what she wants, what she asks for, well, then what's she going to do? She has to actually work on her case. She can't be the fighter, martyr, victim, savior, all this. She has to actually do something about it. But she doesn't want to. She still wants to live in her head and have people think what she wants them to think of her. Continuously pursue. And she's asking questions about, how do I do this? He's already told her, this is how your discovery is going to be provided to you. They don't have an obligation to give her the actual boxes. They have to give her access to her discovery. And the access has to be reasonable. To have access for 8 hours a day is pretty reasonable. So he's answered that question. And he said to her, well, I can't answer this question about continuously pursuing because that would be me giving you legal advice, and I can't do that. He's the judge. He can't do that. So she just asks again in a different way. And the answer is going to be the same, which is, I can't answer that.
Right. Okay, so I guess I will figure that out, because if I'm up at 2 o'clock in the morning, I can't utilize the laptop, which is another reason why I was looking forward to the hard copies.
Really, Sarah? That's why you were looking for the hard copies? Because all along you have been saying that there is no privacy there. So the hard copies would be bad. If they gave her the actual boxes, that would be bad. She would complain about that. And she would have some legs to stand on with that, because she said, I told you there is no privacy. Well, they've problem solved for her. Yet again, it's somebody else. She complains and everybody else has to solve the problem. But if I want to do it at 2 o'clock in the morning, well, guess what? You know what? It's like a regular job, Sarah. Do you know what that is? You go to work at 8 a.m. and you're done at 4. That's actually pretty nice, because a lot of us go to work at 6 and we're done at 8 p.m. or later. That's pretty good. And she seems to not understand that you don't get to just do what you want when you want. Oh, yeah, right. She wants what she wants when she wants it, how she wants it. But even in real life, for people who aren't in custody, you can't just do what you want when you feel like, work on something when you feel like it. I understand waking up at 3 o'clock in the morning and getting some work done. I understand that. But most people don't have the luxury of just working on something when you want. It seems that she wants every whim accommodated.
So my other question is my time prorated for the time that I've been waiting for my discovery?
I'm not sure I understand what that means.
It's like she's talking to a teacher, like her project is in late. And you know what, teacher? I didn't get your full instructions until, 5 days later, so that my deadline should be extended. That's what that sounds like. She's asking for her trial to be delayed. Didn't I tell you? She will try and wriggle around and figure out some way to delay this again. And I don't think he's going to have it.
Will I be having additional time added, or will it be extended from the time period of me waiting for my discovery still?
I'm not in a position to answer that question. I don't know what it is that you're asking for.
My pretrial is supposedly set for September 24th, I believe it is. So obviously I will not be prepared And obviously, I do not know what I'm doing, and obviously, I'm still waiting for my discovery. So for that time period that I have been waiting for almost 4 weeks now, will that be added to the time frame in order for me to be properly prepared?
As of right now, the dates are what the dates are, ma'am.
Okay, so I just miss a week, a month.
The dates are what the dates are.
So I also sent you, I believe, 5 motions. Have you received those?
No, ma'am, I have not.
They were mailed last week.
Then I have not received them yet. The last correspondence I got from you, ma'am, was received on July 8th.
Okay. 5 motions I've mailed. They're probably sitting wherever else it is, considering it takes a day for you all to receive my mail, considering I'm right down the street from you all. So I have those all.
Wow. Maybe she's going to sue the U.S. Postal Service now. I think the sarcasm is uncalled for. 5 motions. That's going to be interesting.
Also in order, which may change whatever information or anything that I'm trying to acquire in between now, the month less that I have in order to prepare for my trial. That's in October. So if you could keep an eye out for those also. I don't know who I'm supposed to ask. How did Mr. Lane come into any of this? Like, how was he called?
Mr. Lane has been your investigator in this case, and he was advised to attend this morning's hearing by virtue of being provided the discovery in order to digitize it so that you can have access to it.
The court contacted him?
I did not contact him.
Am I allowed to speak to him directly?
You can?
Mr. Lane, who contacted you in order for you to be here, please?
The JA contacted me.
If I'm pro se and my own attorney, shouldn't I be included in all of this so I know what's going on and not a surprise hearing like it is again for the second time?
She's still on about who called you. How'd you know to be here? And she's still on about notice, not getting notice. I mean, how dare you, Judge? How dare you bend over backwards and gather all these people from all these different agencies or institutions, gather them all and work together and come up with a whole new procedure so that you can give me what I want and take all my concerns like privacy into consideration and protect my rights. How dare you do that and not give me sufficient notice? I should have had something in writing maybe. Well, that would take more time. And if it takes more time, well, then the complaint is going to be, well, you're wasting time. She's already complaining. Well, I'm not going to have enough time to prepare. Honey, you've had 4 years.
Ma'am, again, this is why there were benefits to being represented by counsel. The court has already identified in its 16-page order the reasons for why you no longer have those benefits.
Right, which
It
is
makes things
malformed.
exceptionally more difficult, as I explained to you in communicating
Did she just say malformed? Because she didn't bring her thesaurus.
with the court and communicating with the state attorney's office.
Isn't that what a certificate of service is for anything that's filed by anybody in the court?
There
That
was,
should be included in that.
ma'am, there was no certificate of service for setting this for today. This was coordinated by the JA. You were advised as soon as it was set. It was set yesterday.
It's just very odd to me that the news knew about it before I did.
Again, I can't speak to that.
And so nonetheless, my constitutional right to counsel is being forfeited on your behalf in the court. So now I don't get appropriate notice in preparation for me to be able to be here and doing what I'm supposed to be doing and act as and perform as?
I've already addressed the reasons, ma'am, for why there was a forfeiture and alternatively a waiver in the 16-page order that you were provided. Again, it's difficult to communicate with you based on where your current housing is. I'm not able to pick up the phone. The judicial assistant's not able to pick up the phone to communicate with you or send you an email to schedule certain things. And it leaves a little bit of a level of further complication.
How is it the news knows before I do?
You keep asking the same question and the answer is going to be the same. I cannot answer that question for you because I do not know.
Okay, but you do know it's harder for me.
I would agree with that, yes.
And you do know that you did not ask me any questions in regards to your order. You just read it straight off and never asked me what's what or how many with anything of it.
Ma'am,
I guess he was supposed to collaborate with her in crafting his order. It sounds like that's what she wanted, except two things. One, he can't contact her. He's the judge. He's not her lawyer. So he can't have this collaborative conversation with her. And it would require more time. One of the things here that everybody is having to deal with in making sure her rights are protected, so like her right to privacy, her right to see her disclosure, to have reasonable access, her right to prepare and defend herself and all of that, in accommodating her, they also have to consider everybody else's rights. So the rights within the jail for, say, people's safety, so that cable can't be in the housing unit, for example, right? Because it's a safety hazard. There's a balancing act that has to happen that they have to all work through in order to accommodate her. And I bring it up in every video, and I'm going to do it again. Mr. Torres's family has some rights. The public has some rights here. All of this has to be balanced out. Everybody's doing this big collaborative effort. There's a big balancing act. There's a lot of back and forth to make sure this gets worked out. All of this costs money. All of these people's time costs money, and it costs effort. And there are other people in the system aside from Sarah Boone. Now, that's not to say that she should not be accommodated. She is entitled to have her rights protected, and fine, that's fair. What she fails to see consistently is that the world doesn't actually revolve around her. As much as she thinks it should, it doesn't. And all of these people have other things they have to also consider. And every other inmate matters just as much as she does. And Mr. Torres's family matters as well.
If you have questions, I can certainly try to answer them. I'm trying to facilitate you getting that information that you're certainly entitled to. And it took time for a process to be created by the Orange County Jail. As they had advised me, they do not have a place to store 2 banker's boxes of information, nor are they in a position to provide you physical copies. This is what I've been advised as the process is. As soon as that process was finalized, I set the hearing. This was finalized yesterday.
No one ever asks me. I've been waiting for the boxes. I really don't know what to say, and because I supposedly have no way to contact you other than a letter, and the same for you, I don't know how the news crews got here before I did, but I don't know going forward, how is it that I'm supposed to be able to communicate with you other than me sitting here in front of you at these, I guess, supposed surprise hearings that I'm going to have every single time that it is that you would like to speak to me? Is that
so condescending? And I guess supposed surprise. She's so sarcastic and condescending. There she sits in handcuffs, in custody, talking to the judge as if she is a mom or a nanny scolding a 5-year-old. Oh, is this the way it's going to be? Huh? Is this what you think you're going to do? You know, you're wrong. Shame on you. This is the message. This is how I'm going to be going forward. Could you imagine dating her or living with her? Oh my gosh.
what it's going to be?
Ma'am, I cannot answer that question. All I can tell you is that you can communicate with the court through the avenues that you've been utilizing previously by and through letter writing. As I said, I do not have your letters that you sent last week. They're not in the court file, and they were not in my inbox yesterday. So as soon as I receive them, I will diligently review them, and if we have to set a hearing, you'll be properly noticed for it.
In the certificate of service?
You'll be properly noticed for it, yes, ma'am.
And will they...
She wants a certificate of service. And his answer is, you will be properly notified, because that notification may not take that form. She should be careful about what she demands, because if she wants paper that she can hold in her hand, that takes time. And that means delays, and her trial date is not going to be delayed as a result. So she should be thinking about what are the consequences for asking for things to be done in a particular way.
Will be a proper notice for today?
Notice was performed last night. I've already explained.
Ask the news crews how they got here?
No, ma'am, I'm not going to let you do that. They're not under oath. They're not a party to this action right now.
The level of entitlement just blows my mind. She thinks that she should be able to demand of the news crews how they got there. Oh my gosh.
It's wrong and it's unfair.
You certainly entitled to that opinion.
Am I allowed to ask him a question?
Sure, go ahead.
Mr. Lane, how is it that you and I are supposed to be speaking to one another?
So my suggestion would be, since you're now the attorney and you are pro se, that either you or your honor gives me access to the jail to come visit with you, and I will be happy to do that. It is the policy of the Orange County Jail to have a letter represented from an attorney to allow me to access you. That's the reason for the past previous couple of attorneys I've not had the ability to come out and access you, but that's changed. And I will be happy to continue to move forward with any investigative actions I can do for your defense, as long as I get that access.
So you need a letter from me.
Or the judge or the jail, somebody that will allow me access to you. Yes, ma'am.
He has had this conversation with her before, and that's evidenced through an attachment that she sent in one of her letters. These communications where he has told her this very thing. So she knows this. I feel sorry for him if she's going to be pestering him the way she pestered lawyers, although he's not subject to the same kind of rules as what would be required of a lawyer. So he has a certain scope. So she can't ask him to do absolutely everything that she wants. So we're going to have to wait and see how that goes. I wouldn't be surprised if we get a letter complaining about him and how he's not doing enough in the future. We'll see.
And I send it to you directly?
Yes, ma'am.
Is this a letter also that you'll be supplying to him?
I don't know that I'm in a position to compel the Orange County Jail to do anything.
But you all are the ones who contacted him.
But I can't tell the jail, let this person come talk to you. If they have a policy where you need to provide the letter, then you need to provide the letter.
So until you have that letter, you and I will not be able to speak with one another?
I will contact the jail myself and find out if there's an exemption from pro se, or maybe they can speak to you directly to circumvent the actual letter itself.
Thank you.
Ma'am, do you have any other questions?
I don't think you have enough time. I'm just doing my best, and if you could please keep an eye out for my motions.
I will be on the lookout for them. You said there were 5, correct?
Yes.
All right, I will be on-
If you could please include me on the certificate of service for whatever hearings that we have that are no longer a surprise for me, please.
Understood. You'll be given a copy of the court's order that I read momentarily, and I will see you both on August 5 at 8:45 in the morning. All right, thank you all very much. Mr. Cacciatore, anything further, sir?
Nothing from the state.
All right, thank you very much.
Thank you, Your Honor.
Thank you, sir. Have a great day. Oh, wait, before you leave, that is all going to be yours. Yes, I would, sir, so that you can begin the digitization process. All right, I'll see you on the 5th.
I'll have you return your.
Perfect. Thank you, sir. Yes. I'm just. Sir, can you just hang out for a second so I can give you a copy of the order? Appreciate you. Thank you.
Well, that's the hearing. I guess we're going to have to keep our eyes open for motions. I want to say a big thank you to the person who sent me footage and the actual court documents. Sometimes I can't get to them quickly. So when somebody sends me the actual documents, I really appreciate that. And I just want to say thank you very much to that person. That's all I've got for you for now. Trust your gut. I'll see you in the comments.